With you on the line with us is Professor Mark Tushnet. He is the William Nelson Cromwell Professor of Law at the Harvard Law School, author of numerous books, including Taking the Constitution Away from the Courts. His Harvard, hls.harvard.edu is his website, and you can tweet Harvard_law. Professor, welcome to the program.
Hi, thanks for having me.
Thanks so much for joining us. I wrote a book back in 2000, Unequal Protection, about the history and the arc of the history of corporate personhood and the Santa Clara decision and all that kind of stuff. And a chapter of it was about, you know, Jefferson's reaction to his second cousin, John Marshall's decision in 1803 in Marbury, you know, and this whole idea of judicial review, that the Supreme Court can strike down laws. Can you give us a quick summary of what the policy of or the theory, or whatever you call it, of judicial review is, and how it, and your thoughts on it? Let's start with that at that point.
So the basic theory is that the Constitution sets out particular provisions that define the boundaries between the branches and limits on government power. And we need to have some mechanism to ensure that those boundaries and limits are respected. Judicial review is said to be the mechanism that we have to ensure compliance with what the Constitution says government should be able to do and what it can't do.
And yet in Federalist 78, when Hamilton was trying to sell the new Constitution, he quotes people saying, well, you know, if this Supreme Court happens the way you're defining it, they could ultimately, you know, strike down laws and become like, you know, petty kings, petty tyrants. And then Hamilton goes on to say, no, they will be the least likely to offend. They have the least power. They have neither the power of the purse nor the power of the law, all that kind of stuff. Did this actually start in 1803 with the Marbury decision? My understanding is it was only used a few times in the 19th century, in Dred Scott, for example. How has this evolved, the right of the Supreme Court to actually strike down laws made by Congress and signed by the President?
So both parts of the early history story are quite complicated. There was a pretty well-established tradition of what we came to understand to be judicial review before 1803, and there was a fairly robust practice of saying, the court saying, this statute would be unconstitutional if we interpreted it in a particular way, and so we will interpret it to make it constitutional. Over time, particularly starting in the late 19th century and through the 20th century, the courts became more active in asserting the power to strike legislation down. And after a period in the 1930s when the court's practice came under quite severe political criticism, the court changed its approach, still being rather active, but now in the service of more, call it, progressive goals. And liberals and progressives came to see the court as an institution that was basically on their side. That behavior by the court changed in, let's say, around 1970-ish, and the court's political tilt began to change. But by then, the idea of judicial review and its value had been built up pretty substantially among the American people, and liberals and progressives still continue to hope that the court might, at least on occasion, rule in their favor. And as cases like Roe and the gay marriage case indicate, that belief was not entirely false. But if you look at the court's record, again, roughly for the past 40 years, let's say, you see the court as increasingly exercising the power of judicial review to disadvantage progressives and empower conservatives.
Yeah, rather significantly. Phyllis Schlafly used to be a regular guest on our program before she died. Now, I'm a, democratic socialist liberal, and she's a hardcore right-wing conservative. And but we agreed on this idea that when the court engages in basically legislation, in creating law, in not just saying yes or no to a law, but in the case of Roe v. Wade, for example, or in the case of Dred Scott, just coming out and saying, okay, we're going to define these 3 trimesters of pregnancy, et cetera, that basically they short-circuited a political process and thereby created a movement that might not have happened if we had gone through a political process, which I think the country was pregnant with in the 70s anyway. I certainly remember that era. Your thoughts on that and on the courts, the courts, whether it's appropriate or even legal for the court to essentially create law?
The story is about the relationship between the court and political mobilization are always quite complicated. The court helped mobilization of African Americans in the 1950s through decisions striking legislation down. It contributed to the mobilization of conservatives after that with Roe and Wade and decisions again about desegregation. So there's no direct relationship between the courts taking an active role in striking legislation down and enabling or disabling political mobilizations. Having said that, sort of the overall picture over the last century or so is of an increasing sort of rate of displacement of policymaking from the political practice into the courts. Not everything, of course. Tax policy is made by legislatures and so on, but there's a lot more policy in which the courts are centrally implicated now than there used to be.
Let's talk about court stripping for a second. The Article 3, Section 2 of the Constitution says, again, Hamilton quoting it in Federalist 78 or 81, it says that the court shall operate under such exceptions and regulations as Congress shall stipulate. Phyllis Schlafly again told me the story that one of Tom Daschle's farm bills, he was concerned that it was going to be attacked by the court, and they inserted a sentence into it. This is back when Tom Daschle was running the Senate 25 years ago, 30 years ago, that said this legislation is not subject to review by the Supreme Court, and thus creating that exception. Is that a viable policy? Has it been done frequently in history? Is that something that legislators, for example, if Democrats were to take over the other 2 branches of government, might they be able to insert court stripping language into legislation in order to avoid judicial review?
The practice has been extremely rare in U.S. history. There may be a handful of examples, most of which can be explained away as not really taking ultimate power away from the courts. So there's something of I call it a tradition or a convention that you don't use the exceptions clause to keep particular substantive issues away from the courts. It hasn't happened very often. Notably, if it were to be used, it would basically protect enacted legislation against invalidation. But if you think that, for example, state legislatures are enacting unconstitutional legislation, you want the court to be able to intervene. And so the exceptions clause has limited value in overall.
Wouldn't that, though, just toss it to the people? I mean, the question that was, and we just have a minute and a half here until we're going to hit a hard break, I'm sorry, but the question that was put to Jefferson after his rant in 1803 was, well, if the Supreme Court isn't the final arbiter of what's constitutional, who is? And Jefferson's response was the people themselves. They will realize over time if legislation has been passed that's blatantly unconstitutional, and they will elect representatives who will correct it.
Yes, and I agree with that position. You quoted the title of my book, Taking the Constitution Away from the Courts, and the argument there was we should take it away from the courts so that the people could be responsible for enforcing the Constitution.
How? Very quickly.
Through political mobilization, electing people who support their views of the Constitution, defeating people who take positions that they think are unconstitutional, just through ordinary politics, dealing, though, with the Constitution rather than mere policy.
So, in other words, hopefully legislators would be passing legislation that would be less likely to be struck down via the process of judicial review.
Right, that's right.
Yeah. Okay, well, it seems like a starting point. It's probably a pretty good one. Professor Mark Tushnet is the William Nelson Cromwell Professor of Law at Harvard Law School, and his most recent book is Taking the Constitution Away from the Courts. Professor, thanks so much for being with us today.
Thank you for having me.
It's been a pleasure talking with you, and fascinating. It's a topic that I'm greatly interested in. Thank you so much.